Morning. Okay, so this is to address any skeptics out there, maybe they're doubting Thomases, who don't think that seemingly innocuous statements found in medical records on function reports from claimants who might be unaware of how these things will be twisted in the eyes of SSA adjudicators when it comes to determining a disabled status under the rules, the Social Security rules. So, I bring these kind of things up all the time. And a kind viewer was very skeptical about how that couldn't possibly lead to a denial. So I think first, what it's important to know, and I'm going to go through some actual quotes from ALJ denials that I have archived, because I've, had them from over the years when I would look at someone's previous denial and decide if I was going to take them on as a client for a new claim. So I always ask them for the prior denial because I want to see what the prior ALJ, who gives the most descriptive explanation for denial, unlike the lower levels, initial and reconsideration, which give you kind of a blanket canned denial letter, far more canned than an ALJ. Far more. In fact, we even have videos on those denials and how you shouldn't take them to heart. And we go through some of the very more predominant canned denial statements. We're denying you because, and there's a few of them. There's a handful that we go into. So I'll try to remember to link that. I think it's a playlist. But in any event, I have obviously from any case that I ever represented that was denied, but more so I got most of my fodder from ALJ denials I had to review to determine the strengths and the weaknesses in the evidence when it came to a new case and what would have to be done to not let the same thing happen again. Okay, so this is just one. These are a few pieces from one particular denial from a few years ago that I was reading. I do not believe I represented this person, but it had nothing to do, I don't think, with the denial per se. It might have had more to do with vocational profile that would remain and possibly at that time insufficient evidence to see that it would be any different with a new claim unless and until the claimant did something different. So anyway, so let's look at this. The claimant reports, this is a quote now, a direct quote. The claimant reports that she spends time with family members on a regular basis. The judge used that to support his denial. Now, one little phrase like that used to support a denial is not the only piece of evidence, obviously, that the judge relied on. It is but one crumb. And I'm always saying how we need a bunch of crumbs to get to an award. That's why every little thing should be done, in my opinion, to make every case as close to 100%, which it's never going to be, as possible. I would rather have a 98% chance of winning than a 97% chance of winning, but certainly more than a 60% chance or a 40% chance. But every little crumb gets us closer to 100. And I think the same can be true of a denial. Now, remember, the foundation of evidence is always the medical evidence. But when something shows up in medical evidence, like a statement by a doctor or a medical assistant, particularly when they say that the patient says this, that is in a sense part of the medical record, even though it's not like a blood test or a diagnostic. In this case, okay, the claimant reports that she spends time with family members on a regular basis. Okay, so why would that be bad, you say? Often it won't be, but in this particular case, because you have to know all the facts around it, if the claimant was reporting or claiming to be disabled due to mental symptoms from a mental impairment or more than one impairment, such that she is antisocial, easily irritated or irritable with others, low level of tolerance for frustration with others, perhaps argumentative, or often tearful, perhaps upset very easily around others. If there's high anxiety, sometimes, if there's depression, sometimes we're antisocial. We don't even want to hang out with people. And when we do, we're probably less than ideally pleasant, at least some of us, right? So the claimant reports that she spends time with family members on a regular basis. Some ALJs will use that kind of finding, which they probably got from the function report, because it does ask about who you spend time with, if anyone, probably found that this would be inconsistent with the concept that, it shows that someone can interact. It might show, and the judge is using it to support this, might be able to properly interact with supervisors, coworkers, or the public without any inappropriate, propensities. When they talk about interacting with supervisors, coworkers, and the public, if someone has a substantial loss in the ability to do that, that itself is disabling. If there's a substantial loss in the ability to interact with supervisors, because it is said that there are many jobs where we don't have to interact with the public. That, of course, is true. And apparently it is also true there are many jobs that don't require we interact with coworkers. But as far as I recall, there is no occupations, or certainly not in substantial numbers, that do not require that we at least occasionally interact with supervisors. And let's face it, if you, even 1 out of every 4 times, 25% of the time when you interact with your supervisor, you are inappropriate, kind of a guarantee you're not going to be able to keep that job. It's just not going to be sustainable. So if someone has a substantial loss in the ability to do that, and that is documented and proven to the satisfaction of the adjudicator, lower level or ALJ, like here, then that person would be found disabled, entirely disabled by the medical problem. I mean, the mental health problem. So it could stand on its own without even any physical disabilities or additional mental symptom limitations, right? But if the person can do that and is not substantially lost in the ability to do that, then that doesn't apply. So the judge pointing this out is I believe, suggesting that, all right, so we don't have the mental health limitation of import about interacting with other people. So that's not an issue. And that is often part of the issue with mental health disabilities. So if this was a mental health disability case, which it was, this is something that he pulled from that function report to support his denial. Okay. So while you may think, and the doubting Thomases may think that, these innocuous little statements are harmless, and that we are blowing things out of proportion when we say don't do that. Here's a prime example, and we're going to have plenty more, because I'm going to do more of these and pull some of these out for you, because you have to see it. Yeah, you just have to know that all those little questions on the function report, every single one is designed with this in mind, not this particular exact scenario, but it's designed to provide fodder for, sharing something that would belie something later that would be relevant to your case. It just is, guys. That is how this law works and the practice of it. Okay, here's another one. Same ALJ. And again, this is a few years back. I don't even recall what state it's in. I don't have the actual decision in front of me now. I just pulled these out and cut and pasted. Quote, the claimant does not report any attention or concentration deficits when watching television. Now, what's interesting about this, for all of you that have done function reports and applications for yourselves, did you ever see a question posed to you that says, do you have attention problems when watching TV? The answer would be no, because they do not ask that question. What they do ask in the hobbies section of the function report is what your hobbies are. And a lot of the time, many people who are experiencing disabilities, mental and or physical, their television watching has increased because they're not out and about working. There's a 8 to 10 hour day opened up for the, where one of the few things they can do is actually, flip on the TV. So people will say watching TV. The next question underneath that hobby question is, how well do you do this? And if you don't say anything about, it's kind of weird. We think of TV as being a passive activity. So I watch it just fine. There's no competition and there's no standard of good watching TV and bad watching TV, right? As a skill or. So it's kind of an unfair question, only because we're not seeing it the way they're going to be able to interpret it later, like after hearing when they're making a decision. So this person never mentioned anything other than watching TV in the function report and didn't describe, things that probably existed, such as the next day after you watched the movie the night before, do you remember the main character's name? Do you remember who the second leading actor was and all that, sometimes you don't even remember which movie they watched last night, particularly if you're watching one every night. So, or sometimes they'll watch a movie, but they'll zone out, and then you just missed like 10 minutes of the conflict in the movie or whatever it was. And you're like, oh my God, I got to rewind that. How many times do you rewind a movie? I do it all the time. But nobody puts that down because that wasn't asked about. It just said, how well do you do it? I do it fine. Because in my opinion, I do it fine. It meets my needs, Judge, So he used that answer in the function report as one of those crumbs towards this denial. Because, well, we know that she interacts with families, the one thing I just talked about before, on a regular basis. So we don't have an extensive mood disorder that would, make her not do that. And we see here she can watch TV and there's no reported concentration deficits or inattention or distraction, because she didn't mention it. So bottom line is, when you're answering that, it might behoove you to think about everything you answer and figure out, by thinking about how you do it, in what way does that get interrupted by your symptoms? And with television, it would be this attention and concentration. Maybe you don't remember the movie the next day. Maybe you have to rewind it a lot. Maybe you fall asleep in the middle of the movie and you never even get to the end of it. That is what you're going to want to make sure you probably add into your answer somewhere in that function report about that television watching. And it's funny, I hadn't talked about television watching, I don't think, in any of my prior videos. I've talked about other things. But when I saw this in the ALJ denial on this person's case, I was like, ooh, yeah, that's kind of big. So yeah, saying you watch television and it's what you fail to say about it, the omission is what can hang you, like it did this person. Okay, let's go to a third one. I think we have time. Quote, same judge, same claimant who, again, it's a mental health case. It's not really anything about the physical. And I would say she was under 50. She is able to operate a motor vehicle that necessarily requires the ability to focus, attention, and maintain concentration. So while you're answering that you do drive, because there's the driving question, remember, on the function report. We do know that driving is a kind of a sophisticated activity. If you have lots of accidents, but you still have your driver's license, but your accidents have been pretty noteworthy, not so much as serious, that's not so much necessary, but that you have the fender benders, that might be important to note. Now, nobody wants their license revoked medically. But again, and some physical impairments and some mental health impairments, like severe anxiety, where the person can be nervous and jerky, that could make them a dangerous driver. But other ones like seizure disorder, be it epileptic or pseudo seizures, non-epileptic, that would clearly if severe enough and not very rare or in the distant past, be a reason to not operate a car. Another thing that they may look at is, did your doctor revoke, medically have your license revoked until you could stabilize through medications a seizure disorder? If the doctor didn't, that means your seizure disorder is not ironclad, or not very often, or the doctor, pardon me, is incompetent, perhaps. Because literally not revoking that driver's license, knowing someone has a seizure disorder that they say is severe, is kind of lends itself perhaps to medical malpractice, not to mention liabilities to third parties once they get hurt or killed. So when you answer the question about driving, in this case, it was a mental health case, and it just supports the judge's denial because it negates a limitation to concentration and attention and focus that is very severe. Because it was very severe, the person wouldn't be able to drive, in theory. Doesn't mean there's not somewhat of a limitation, but he's going to find that it's not severe because the person can still drive, right? Yeah. So that's kind of, when I go over with my clients the function report, and I'm involved in every function report. They don't go out blindly. I want to make sure they know what questions are being asked. And if they have a response that doesn't seem responsive, I'm going to let them know and ask them why. If the person just checks off, yes, I drive, I always ask them, so is that unlimited? Can you do an 8-hour day? Can you do the superhighway? Is it only local? Can you do night? Can you do day? Can you do rush hour? Can you do strange places or only places that you're familiar with? You'd be surprised how limited many people become in their driving. So even though they still have a license, let's say it's not a seizure person, so let's get out of that. It could be pain, it could be stiff neck. You're not going to drive as well if you can't turn your head and look when you need to. We have mirrors, but that's not 100% what we're supposed to be doing. I would explain whether it's, I have a license and I've used it maybe once a month in the last year, or I go to the store in it, that's 2 miles down the road. I don't go to the doctor's in it because that's 45 minutes away and I need to have a ride. I need someone to drive me. Whatever the case may be, if the shoe fits. If you are completely fine with driving, and there can be disabling conditions that do not affect driving. So that's entirely possible, but you have to know what it would be with your situation, right? I would always put in any limitations I have to driving. Like, I always throw out the whole thing. Do you do it? Can you do it the same way, same skill, same duration as when you were 20 or 25, or whenever you feel you were in your prime? And if it's not the same, that's when you want to make sure it's clear. It doesn't matter the reason why, whether it's because you have a bad pinky finger that hurts holding the steering wheel, or because you have severe herniations with nerve impingement in your neck. The reason right here doesn't matter so much. It's the fact that whatever it is limiting you. The SSA is going to get to your medical records that are going to be describing different limitations from different impairments. So that's not the place to put it, but to put in what is limited about that driving. You see what I'm saying? It's not always best to leave a yes or no question with a yes or no answer. They say, if you don't drive, explain why. Well, if you're still driving, people ignore that then. And I'm like, no, let's use that spot for something informative. And even if the adjudicator at the lower level isn't going to give it a second thought, because generally I don't think the function reports mean much at that level. When you go to hearing, the judge will not have the ability to credibly say, she says she still operates a motor vehicle. I mean, he could say it because you did say you still operate it, but on appeal from that judge, if he denies, you can point out that he cherry-picked and he threaded a needle, because what the answer was about the driving was only very locally, only when I have no other ride, only in the daytime, and only, et cetera, et cetera. And only perhaps on good days. I mean, there might be days where absolutely you don't even get in the car, even though you really need that milk or toilet paper, because that's one of your bad days and you don't dare drive. Okay, I think I'm going to leave it at the 3 because we're going to get too long and then we're all going to fall asleep. But you see what I'm saying? Like, these little things are what are used to put all the crumbs together for a denial cake. We do the same thing when we're trying to build to an award. We want to get every little thing in there, not just by making the function report truly representative and not sloppy, but also with the medical treatment. And as you know, I'm always harping on treatment, impairments, big and small, not just the one that took you out of your job or your career. And there's a video on that that you probably need to watch if it's not sinking in. Okay, so to all you little doubting Thomases out there, yes, those little things are what is used to sink your ship. And what's funny is they can't really sink your ship without the medical evidence being referred to as another reason to sink your ship. But these answers are also what can also, I feel like they can be the things that mentally poke a decision maker, an adjudicator, or a judge as to what his gut feeling is. So you want to give him as much information to come to the conclusion that the limitations that you claim are there. So don't leave him out of these little activities that seem innocuous to answer. And of course I drive, everybody drives, even when they have it. Yes, it's true, but how do you do it differently? That's what you're going to want to get in. All right, because these were all used to sink this person's ship. And it was unfortunate because she's probably still not working to this day. All right, take care, guys. I'll catch you the next time. There'll be more on this just because there's so much to know. And if any of it can be one little nugget to help you improve your case, that's what it's all about. All right, I'll talk to you later. Bye, guys.